Hello everyone, it's Yoli Medina. I'm here doing another video on the Kohberger case. This time it's about his alibi. Now, it seems to have been forgotten that his alibi needs to be determined whether he's going to be able to introduce it or not. Now, the alibi is a procedural type of thing where the judge has discretion to allow the deadline to extend beyond what is in the statute. But the important thing that I wanted to point out, because people seem to think, and rightfully so, that the fact that Kohberger may have been looking at the stars and the sky during the times of the unalivings of the Idaho 4 on November 13, 2022, they think that it's BS. And I can understand that. I mean, you think someone who is accused of a crime is out there driving around in early morning hours looking at the stars in the sky. I mean, that doesn't sound right. But what I want to point out is that Ann Taylor, she used specific words. And I want to point out the objection to the state's demand for an alibi. So let me point that out. Let me share the screen here. So this was back in last year, August 2nd, 2023, when it was filed. So the defense objected to the state's motion to compel the motive of defense of alibi, or alternatively, to bar certain evidence. So I'm just going to read it. Comes now Bryan C. Kohberger, buying through his attorney of record, Ann C. Taylor, public defender, and hereby objects to the state's motion to compel motive of defense of alibi, or alternatively, to bar certain evidence. Idaho Code 19-519 and Idaho or ICR 12.1 require an alibi disclosure of a specific location with a specific location and witnesses to so testify. By statutory definition, Mr. Kohberger may remain silent yet testify that he was not at 111122 King Road on November 13, 2022. However, in an abundance of caution and recognizing that the court has authority to exclude witnesses, Mr. Kohberger has indicated he anticipates corroborating witnesses, so he anticipates this. And I'm not going to go through the quote here on the case, which is State v. Juarez. I'm going to go to the next paragraph on page 2, which says, Mr. Kohberger has long had a habit of going for drives alone. Okay, so that word habit, that's something that triggers a judge to look at habit evidence. And while layperson may think, yeah, so he has a habit of driving around at night, so what? But that's an issue of evidence. And so I'm going to stop this. So when we're talking about evidence, the judge is going to pay particular attention to that. And in Idaho, and I don't practice criminal law. I'm not licensed in Idaho, but I can interpret some statutes. And so the Idaho Rules of Evidence, which is Idaho Rule of Evidence 406, and I'll post it. Here it is. It says Idaho Rules of Evidence 406, Habit and Routine Practice. So it says evidence of a person's habit or an organization's routine practice may be admitted to prove that on a particular occasion the person or organization acted in accordance with the habit or routine practice. And it says the court may admit this evidence regardless of whether it is corroborated or whether there was an eyewitness. So Idaho law allows for habit evidence, and in criminal cases it's generally allowed. So that's what Ann Taylor is trying to establish. And from the very beginning, when I heard this, I understood that Ann Taylor was going to use the state's witnesses, meaning those who pinged his phone 12 times in the area of 1122, where they couched it as stalking. Or they, in the probable cause affidavit, they said they wanted to look into stalking behavior. So in Ann Taylor's mind, in my opinion, she was going to use those experts or those witnesses who put Bryan Kohberger in the area those 12 times, where they said his phone pinged 12 times in the area where 1122 King Road is located. So in a future filing, I know it said, and I don't have it, but it said something about Bryan Kohberger going to look at the stars and stargazing and all of that. Well, I agree. As a layperson, that sounds cheesy. I mean, it sounds like it sounds bad. But those are buzzwords for the judge to understand that this was a habit of Bryan Kohberger. And I do think that Ann Taylor is going to introduce evidence aside from the fact that law enforcement found the pings 12 times in the area before the unalivings, that she's going to show evidence that, even back in Pennsylvania, one of the times that Bryan Kohberger called the police was because he was in a state or national park. I think it was state or national park, and the gate was closed for him to get out. So he needed to get out of the park, and he called the police to get out of the park. So that is what I think that the habit evidence is going to include. And it may include other things. There may be some 7-Eleven clerk that may say, hey, he used to come around late at, like 2 o'clock in the morning to get energy drinks, or he used to come around to get candies, So habit evidence is legit. I mean, it's something that one can use generally in a criminal case to establish an alibi. Now, I don't know about Idaho state law, but it sounds like that's what Ann Taylor is trying to do. And for those who think that it's cheesy that Bryan Kohberger is talking about driving around and looking at the stars and stargazing and at that Wawa Park or whatever, that it's bullshit or BS, It's not. It's an evidentiary type of thing. And that's all. I really just wanted to point that out. And I understand people and the jury can believe it or not believe it. The jury as lay people, they can decide that it's BS. That I don't believe that. But as a matter of law, habit evidence is something that is considered by the judge to determine whether this evidence that Bryan Kohberger, liked to take night drives, or it was a habit that he would do that it's up to the judge whether that is admitted into evidence for the jury to consider. And imagine if you're not married, you don't have a significant other, you're single, and you have a habit of driving around at night or early morning hours. Who's going to corroborate that? Well, Ann Taylor is going to say, these people, law enforcement, who in investigating this case went out of their way to point out that Bryan Kohberger was driving around and his phone was pinging in the area in the around 11:22 King Road 12 times in like 2.5-3 months. Well, I would use those people to establish, hey, you're the ones who pinged his phone around there 12 times. That can show habit, that he had a habit of doing it. Or it could show stalking, which stalking has been debunked by the prosecutor, who he himself said that stalking was a lie, or that the expert regarding the survey was promoting a lie when he was asking people if they were aware that Bryan Kohberger was stalking the victims, or whether they had any information that Bryan Kohberger was stalking the victims. And he cross-examined that expert, and he said, basically, you knew that was a lie, right? And the expert said no. But in any event, I think the stalking information about Bryan Kohberger stalking these people, or the 4 victims, is debunked. I mean, even Mr. Gonsalves said that in an email to one of my friends who's an attorney, he sent an email saying that they were having difficulty connecting Bryan Kohberger to the crimes. So that's all I wanted to point out. And I understand it is weird that, you have some guy driving around at night looking at the stars in the sky. But if that's the truth, that's the truth. And so the jury's going to have to determine whether or not that's believable. Well, first the judge has to make a ruling on it, which it somehow got lost in the shuffle. But I will tell you that the alibi is a procedural thing, and it's under the Idaho Criminal Rules of Procedure, and so the judge has wide latitude to use his or her discretion on when the deadlines for this alibi occur. And I know that in a death penalty case, it's likely that even if a witness were to come at the last minute after the alibi deadline was done and over with, and a witness comes and says, hey, I can't take it anymore. I need to tell the truth. I need to testify that Mr. Kohberger was somewhere else at the time of the murders. The judge has to let it in. And it's up to the jury to decide whether they believe it or not. So, I don't know. I just wanted to point that out, because I do understand that a lot of people don't buy it. And it's fair. But there is law that governs this type of situation. And I just want to point that out because it's not black or white like we would like it to be. Anyway, let me know what you think, and I'll talk to you guys in the next video.